Regarding, I just want to mention, I mean, this is just my personal opinion. This law and just accepting funds in general is the responsibility of the school district. You're saying that you can accept it, I mean, not the school district, the school board. You're saying that you can accept it without a public meeting, and that is based on your legal advice. But that should have been advice sought by the school board. So I guess I'm not understanding, whether it be from you, because I know that would go through the chair. I'm not understanding why the letter could not have been shared with other members in the absence of the superintendent. Because this is the responsibility of the school board.
Because of attorney-client
given
privilege
that?
and a history of this kind of stuff ending up being leaked to the public inappropriately, we have attorney-client privilege, and if any member of the board wishes to go to the SAU and see a read-only file, that is often the case with letters that are sensitive and letters from our attorney. There are times we get letters in our packets at board meetings that must be returned to Mrs. Danahy. They don't leave this room.
No, and that's fine. My point is, I guess I'm not understanding if it's the responsibility of the school board to potentially hold a public hearing, and you don't know if you actually need to meet that criteria as the school board.
I knew.
Why did we seek, why was the SAU looking for the legal opinion then?
Because we had had our last school board meeting of the year, and as school board chairperson, I'm quite busy through the summer while the rest of the board takes a recess, being on top of any issues as on behalf of the board. That's my job.
So
and so I was well aware, and I asked Dr. Metzler to consult the attorney to find out exactly what needed to be done. So he consulted, and Mr. Stokinger both, consulted the attorney on my behalf, and I was acting on behalf of the board.
So you were actually, the privacy was with you then? The privilege was with you? Because
No, they
were...
authorized me to seek legal advice whenever I want, as a policy,
Yeah.
whenever I need to. And so it was our legal advice. She asked me to get legal advice. And they also have authorized Mr. Stokinger to accept funds on behalf of the school district. That happened at a meeting. So, you know, we're into, again, the public meeting, which we may have to have one next year because we're not anticipating a surplus. And if we get some of this, we may have to have that meeting if we're going to spend it at the end of the year. So you may get your wish, and we may end up having a public hearing.
It's not necessarily my wish, I just want to make that clear. We're just, you know,
Yeah. But
trying
that's,
to
yeah.
get
They
on the
authorized
same
Mrs.
page.
Stokinger to accept funds, and I seek legal advice if the chair asks me to seek legal advice on behalf of the district, I do. But it's attorney-client privilege with myself and the business administrator when I seek it. Certainly, Mrs. Steenson could contact the attorney herself if she so sought.
yeah, perhaps that might be, I know you're busy, but if you need legal advice and it needs to be shared with the board, I don't think a vacationing superintendent should limit that.
It didn't need to be shared with the board immediately. There was no immediate need to share it with
It
the board.
was, so it was requested.
It was requested.
No, we wouldn't have spent money seeking legal advice if there wasn't the false allegations that we broke some sort of law.
Exactly.
That's the only reason we even went for the legal advice.
Correct. That's correct. And you are way over on your 3 minutes.
Okay.
If I may ask the next.
Thank you. Thanks.
Certainly.